It's 9 o'clock, and I would like to call this meeting to order. Thank you for joining us during our weekly virtual MLS breakfast meeting. My name is Shen Zhang of VMAX 1000. A few housekeeping tips. All participants will be muted, and should you have any question or comments, please remember to type them into the chat box. Please remember to join us weekly as we will have our virtual MLS breakfast meeting every Thursday at 9 a.m. As always, this meeting is being recorded and will be available online on our YouTube channel, West Singapore Rally Realtors. Please remember to follow WSGVR social media on Facebook, Twitter, and Instagram. You can also watch our pre-recorded videos on YouTube. The WSGVR introduced a new text message service. For updates, text WSGVR to the number 72727. A little about me. My name is Shen Zhang, and I'm the September MLS Program Chair. Today's agenda consists of our affiliate spotlight, Michael Brooks, Direct, our 2020 WSGVR President Message by Mindy Ye, followed by our speaker, Dennis Block, Law Office of Dennis Block and Associates. Just a reminder that to be eligible for today's raffle, you must be a WSGVR member and your DRE name must be displayed on the chat box. No telephone number will be accepted. So if you have a different name as your DRE name and your login name, please make sure to put in your DRE number when your name is called. Today, our affiliate spotlight will be Michael Brooks, Direct, brought you to by Affiliate Committee. Take it away, Michael.
Okay, hey everybody. Many of you know me, I think, who are on this chat, but my name is Michael Brooks. I'm a tax attorney. Direct stands for Domestic and International Real Estate Closing Tax Services. It's an acronym. And all I do is help foreign sellers of U.S. real estate with their withholding tax obligations. Everybody knows if you're not a U.S. person and you sell real estate here, you're going to be subject to a 15% withholding tax. There's a lot that the seller is going to have to do. They're going to get that money back probably unless they made a huge profit, and that can be large dollar amounts. So my job is to help your client get their money back, help them get ITINs, help them do expedited refund applications, 828Bs, help them do tax returns, what have you. We also help if the non-US person is renting out the real estate. There's also some tax obligations there. So anything with a foreign client, a non-American who doesn't live here full time, we can help. They're going to have some tax obligations when it comes to their ownership of real estate, and we can help. That's my contact information. I think most people probably know who I am on this call. And let me introduce briefly Angela Lee, who works for me, who has a special connection to your Chinese clients generally.
Hello, my name is Angela Lee, and I work with a lot of clients from China, help them with their withholding tax, and I speak Mandarin and Cantonese. If you have any foreign clients, especially from China, please contact us. 大家好，我是 Angela。我们公司呢，就是帮助外国客户做房地产预扣税快速退还、税号的申请，以及外国客户在过去几年中售了房之后的他们的预扣税的退还，我们也可以帮助他们。包括外国客户在这里投资出租房屋的话的收益的报税。如果您有任何外国的客户呢，请跟我们联系，谢谢。
Okay, so that's all. You have our contact information, Michael at Direct LP, and our WeChat. Let's hope it still keeps working throughout the fall here and onward. So thank you very much for having us, everybody. It's a pleasure to be here. Thank you.
Thank you.
Yeah.
Thank you, Michael and Angela. We would now like to move to our top affiliate introduction for today. We have Sandy Franco, First American.
Can you shut up?
Warranty.
Good morning, everyone. Sandy Franco, First American Home Warranty, here to provide your buyers with exceptional home warranty service. Call me if you need me.
Thank you, Sandy. Angie Tang, First American Title.
Angie Tang, First American Title. Great seeing everybody. Hope everyone's doing well. Stay safe out there. And here to help you guys grow your business. Thank you guys. Angie Tang, First American Title.
Thank you, Angie. Next one, Teresa Lam from Caribbean Title Company.
Good morning, everyone. I'm so grateful for another day. I miss being in a person with all of you, and I look forward to one day soon. Have a wonderful day.
Next one's Cosmo Sanchez from New Aim Funding.
Hello, good morning, everyone. My name is Cosmo Sanchez, home lender with New Aim Funding. Thank you.
Thank you. Nancy Chan, Lawyer's Title.
Good morning, everybody. Nancy Chan, Lawyer's Title, 39 years, still at your service for all your title needs. Thank you. Have a wonderful day.
Thank you, Nancy. Next one, Amin Adini from Amin Adini Environmental Service.
Well, hello, my friends. If you have any questions about phase 1 and phase 2 environmental site assessments, always call me. You can talk anytime, and I wish you a very, very beautiful day.
Brendan Savensky from First American NHD.
Good morning, everyone. I hope everyone has a great day. Again, this is Brandon Savransky with First American NHD.
Thank you, Brendan. Mark Wu from Allstate Insurance.
Good morning, everybody. Marco with Allstate Insurance, 5 languages out of our office, and here to help you with your fire insurance needs.
Okay, now we'd like to move to our open pitching to our virtual MLS breakfast meeting. Let's get started. Please limit your pitching to 30 seconds. The first one is 2304 Kali Adrina from Agnes Ma with Century 21.
Hello, hi, this is Joyce Chang with Century 21 Citrus, pitching with, for Agnes Ma. And this house is located in the prestigious villas of Rancho Villaverde. It has the biggest lot of 3 bedrooms house on the street and is located at the end of cul-de-sac. And then you can enjoy your privacy.
Anyway, this property is in 2304 Calle Adriana San Dimas. It's, as Joyce said, it's the biggest lot in the cul-de-sac of 3 bedrooms. It's also at the end of the cul-de-sac, so that means there's it's in a peaceful, quiet location, and there's lots of parking if you have parties or guests. Please use showing time, and we are looking forward to seeing you in this beautiful home. Thank you.
Thank you, Joyce and Agnes. Next one.
Good morning, everyone. This is Tomas Wong with Coldwell Banker George Realty. This is a commercial listing at 300 East Valley Boulevard. It's the key corner lot between Chapel Avenue and Valley. It's listed for $1,080,000. It has been used by the enterprise, rent a car for over 20 years, and they decided not to exercise the lease option to renew. The zoning changed since 1990 to VSP for Valley Corridor Specific Plan, which allows the use of business offices for professional, medical, and financial services. We welcome investors to reuse this lot with a conforming zone. Thank you. Next.
Next one is 1836 Fruitvale Avenue in Namonte.
Yes, the other listing is a price reduction. It's a duplex, and the city of Monte, the price has been reduced $41,000 from $1,080,000 to $1,039,000. The owner is very motivated to sell and would like to relocate to San Diego to be closer to her relative. Thank you. Back to you, Sean.
Thank you, Thomas. Now we'd like to have our 2020 WSGVR President message by Mindy Ye. The floor is yours, Mindy.
Thank you, Sean. Good morning, WSGVR family and friends. I'm Mindy Ye, your 2020 president. Thank you for attending our weekly virtual MLS breakfast meeting, and we're always grateful for your continued support as a valuable member of West San Gabriel Valley Realtors. Would you please join me in a moment of silence in observance of tomorrow, September 11, back in 2001, it's called Patriotic Day, in loving memory of and honor our heroes and firefighters. Thank you. Would also like to share this with you from Mark Givens, Amazon #1 bestseller author, speaker, founder of Trust-Based Philosophy. It's all about mindset, determining and focus, and you can make a difference. Mark says, several weeks ago, I was at a church in a foreign land. Well, it was just Myrtle Beach, but that's pretty foreign to me. As the organist was finished singing her prelude music, she slid slightly to the right on the organ bench, which accidentally moved her fingers to a whole new set of keys. It didn't take but 2 beats for her to adjust and correct her fingers. But for a brief moment, those new different keys created a sound that startled most everyone in the chapel. It was both unexpected and amusing. Not laughed out loud amusing, and certainly not laughing at her amusing. And we all knew she was terribly embarrassed. But to me, it was interesting in how a simple act can change the entire meaning. Our lives are just like that. Slight change can make significant difference. Make a slight change ever so positive, your relationships can improve. Make a slight change ever so negative, and you can lose your job. Make a slight change ever so positive, and can win a gold medal. Make a slight change ever so negative, and you can drive off a cliff. The key then is make those slight but significant change that will benefit you the most. Today, take a few minutes and decide whether to move your fingers. That slight changes will change your life. Smile, have a great week, and keep building trust. By Mark. CAR, California Realtors updates. CAR wants to remind its members there is a relief fund for realtors impacted by wildfire and other natural disasters. The CAR Disasters Relief Fund was established in the wake of the devastating 2003 California wildfire and provided grants for realtors, employees of realtors, and association staff who have incurred loss and or financial hardship. If you have been affected by the wildfire and a recent natural disaster, you need assistance, you might apply for a grant from CAR Disaster Relief Fund. You can also make a tax-deductible contribution to those in need. Also for Proposition 19, a ballot measure sponsored by CAR is launching its first statewide television act. The 2 television acts are running now in Los Angeles and Bay Area and will be running beginning statewide. It's regarding campfires in 2018. I would also like to thank our special guest today, eviction attorney, Mr. Dennis Block. Please also join us next Thursday, September 17. Political representative from NAR, National Association of Realtors, will give us an update on NAR federal updates. Additional information will be available by end of this weekend. Thank you, Sean. Take it away.
Thank you, Mindy. At this time, I would like to welcome our speaker, Dennis Block. His topic will be, what are the aspects of the Tenant Relief Bill, AB 3088. Dennis Block is the founder of law firm of Dennis Block and Associates. His law firm spans 4 decades of representing income property owners and consists of 19 attorneys. His firm has conducted over 200,000 evictions. His firm represents municipalities, the federal government, real estate management companies, and of course, mom and pop's owners. He has been past president of the Apartment Association, and in the past has hosted a weekly radio show. Mr. Block conducts numerous seminars for fellow attorneys, and income property owners. At the end, we will read out all the questions to him. Mr. Dennis, the floor is yours.
Thank you very much, and appreciate everybody coming. We have so much upheaval in the income property landlord community, and it seems that every bill that gets passed is only worse for our industry. Truly a trampling on the property rights of our citizens, but that's what we're getting from our elected officials. So we had on August 31st, we had the governor and the state legislators passed AB Assembly Bill 3088. It causes, again, great havoc on our community. It was passed actually due to what a body of the California government called the Judicial Council did, and which I've spoke about to this organization before. The Judicial Council passed emergency rules without any legal authority, since they don't have the legal authority to create laws. And they basically stopped every eviction in the state of California, whether it was related to the pandemic or not. My law firm filed suit against the Judicial Council for having no authority to do what they did. And I am very happy to report, and thanks for the donations that some people made, that the Judicial Council realized the error in their ways and revoked their illegal emergency rules so that lawsuits could then proceed in unlawful attainers for evictions of tenants. But of course, as soon as that law expired, that they revoked it, we had the wonderful people in Sacramento create this AB 3088, which did impose certain severe limitations on landlords to collect rents. In other words, what we have, as usual, is that our government has made income property owners, landlords, they have forced us to become financial institutions, forcing us to give interest-free loans, which truly will turn out to be rent-free. So we're basically going to give our services away for free. As realtors, you can imagine going through the sale of property and expecting to get your commission, and then the government telling you, well, you'll get that commission in 1 year. And quite frankly, where is that going to happen after the 1 year, where you're going to go back to the seller of the property and attempt to get your commission? But that's where it is right now. Let me go over what the parameters of the bill is. It's not only is it controversial, but it's subject to so many interpretations that we're just going to see a tremendous amount of litigation on this. The bill itself is so poorly written that the bill refers to civil codes when they're really trying to refer to codes of civil procedure, two different statutes. The bill is so poorly written that they couldn't even get their statutes correct. So they refer to statutes as that don't exist, because they really meant to say that it was a code of civil procedure versus saying civil code. But let's go over it. Let me tell you some of the cracks in the law that will assist income property owners to get back their possession of their property, and also what rules we now have to follow just merely to evict a tenant who's not paying you the rent. Let's first go over cases that can be brought now. In other words, the ones that are able to proceed, there are no limitations. I can get a summons issued, I can file a lawsuit, I can get a judgment, I can get a sheriff to enforce an eviction. So let's go over those right now. These are noteworthy that if you have any clients who are in this situation, or for yourself, that you will be able to proceed forward with an eviction. Seems like not that big of a deal, except for what's been happening since March of this year, when basically all evictions were stopped. If you have a tenant who has violated a term of their rental agreement, excluding rent, of course, those cases can immediately be brought forth. Those cases can immediately be brought forth. So for example, if you have a rental agreement which limits the amount of occupants and they bring in extra people, I can file that lawsuit right now to evict the tenant. I can't potentially evict that same tenant who isn't paying the rent, but I could evict him if he brought in additional people. If, for example, it was the rental agreement called for no pets and they brought in a dog. Also, if they've made alterations to the premises, that was done without the landlord's consent. And also another one where you have a tenancy which terminates by its own terms. So let's pretend, for example, a tenant hasn't paid rent from March forward in time. We're now into September. And I'm going to be explaining the onerous that this bill has put on landlords from enforcing their own contract rights. But if, for example, that same tenant who hasn't paid rent since March, but that tenant happens to be on a lease agreement where that lease expires on September 30th, I'm going to be bringing forth that lawsuit on October 1st. I'm not going to be bringing it on the basis of non-payment of rent. I am going to be bringing it on the basis that the lease expired as of September 30th and you should have vacated. That's a case we can bring forth right now. So once again, if you're dealing with any case where there's a breach of the rental agreement, which doesn't involve rent or a termination of that rental agreement, those cases can be brought forth now and you can get out of the onerous of not being able to bring forth an unlawful detainer action. Let's move on. All cases where rent is owed prior to March 1st can be brought forth right now. And I can serve them with a 3-day notice to pay rent or quit and proceed forward with that eviction as of October 5th. So for example, you have a tenant who hasn't paid rent since December of 2019. We're now in September of 2020, and that tenant hasn't paid rent for the last 11 months. 11 months that tenant hasn't paid rent. That lawsuit can be brought forth right this moment, but not based on any rent that became due in March or thereafter. I would file a 3-day notice for rent owed from December 1st through February 29th. I would serve a 3-day notice, even though he owes me 11 months, I'd serve a 3-day notice only for that period of time where it was prior to March 1st. So therefore, for that 3-month period, December, January, and February, I would serve a 3-day notice. I'd wait the 3 days. If I didn't get my rent, as of October 5th, the courts are wide open for us to proceed forward with an eviction. Wide open. Now, there have been many cases that my law firm has filed and other law firms where rent was owed way before the pandemic. So again, for that same period, but I had already filed an eviction lawsuit. I already had a summons. I had already served the tenant with the lawsuit. And I was ready, of course, to take a default since the tenant hadn't answered. Well, because of what the Judicial Council did back on April 6th, 2020, I was prevented from taking a default. But now with the Judicial Council, eviction, emergency rules, eviction moratorium, which have now ceased, I can now take a default on those cases as of October 6th. So those are cases that are already in process where I already have a case number. So basically, to recap, if it's a violation of the rental agreement, not involving rent, in most cases, I can proceed forward with that. If it's a case involving non-payment of rent, but the rent was owed prior to March 1, we can go forward with those cases right this moment.
The only thing though, then.
Another thing that we can do is also dealing with commercial establishments. With commercial established AB 3088, I think we're getting some background. I think somebody needs to mute themselves if anybody can hear me. But with regard to commercial tenancies, those tenancies do not apply to AB 3088. So unless there's something else involved, which I'll go over in the interim, those tenants right now who haven't paid their commercial rent can proceed forward with based on non-payment of rent. If it's on a month-to-month tenancy, you can serve a 30-day notice. So there has been a lot of relief for landlords of commercial establishments in that AB 3088 does not apply to commercial establishments. So that's all the good information, the help for residential and commercial income property owners, where if you have a problematic tenant, whether he paid rent or not, if we can bring forth an eviction on that basis of what I've just described, that's something that you should consider right now. Because when I get into what the rules are and what the factions and factors of AB 3088, the Tenant Relief Act. Now notice they didn't call it the Landlord Relief Act. And they didn't call it the Landlord Relief Act because it's no relief for landlords. It's only relief for tenants. So let's talk about what the bill actually talks about and what landlords have to comply with and how basically their rent is going to be taken from them. When we talk about AB 3088, we have to keep two time periods in mind. One is called the protected time period. The other one is called the transition time period. And you have to be cognitive of both time periods. And I'll tell you how they interplay with this wonderful statute that has been promulgated as of August 31st. So what are we? We're 10 days into this statute. So let's talk about protected time periods first. The protected time period deals with rent owed from March 1st, 2020 through August 31st, 2020. March 1st through August 1st. The transition time period goes from September 1st through January 31st, 2021. Those are the two time periods, protected versus transition time period. So let's take the first one where we're going to call that protected time period. That's from March 1st through August 31st. If you have a tenant that owes you rent between that time period, you are required now, don't think about a 3-day notice to pay rent or quit. You can throw those out the window. It's now a 15-day notice to pay rent or quit that needs to be served for that time period. If they also didn't pay rent for September, which goes into the transition time period, you got to do a separate notice for that. We're going to hold off on that. Let me finish the ones for the protected time period. Once again, March 1st through August 31st. Right now, you would be serving a 15-day notice it has to state for each month what amount was owed. So you'd have to state, for example, if it's $1,000 a month, that $1,000 was owed for March 1st, $1,000 was owed for April 1st, and so on until we got to August 31st. So whatever owed, you have to have a total, but you also have to separate it for what is owed for each month. That notice is served on the tenant with two other documents. Those other documents are an information sheet to the tenant and also a declaration that the tenant would need to merely date and sign, assuming he can declare what that declaration is stating. So the information sheet basically tells the tenant the following. If, in fact, your inability to pay rent between March and August was due wholly or partly due to the pandemic, then your obligation to pay rent is suspended if you merely sign that declaration that we had to supply with our 15-day notice and date it and get that back to the landlord within 15 days. If the tenant returns that returns that declaration to the landlord within 15 days, that rent is delayed, it's deferred. So when is it deferred to? Well, it's actually deferred to February 1st, 2021. So they would have until, it's actually January 31st, 2021. Then by that point, the tenant would have to pay that sum of rent. So once again, you're going to serve a 15-day notice on the tenant for that period, March 1 to August 31st. You're going to serve it with that information sheet, which basically tells the tenant, hey, you know what? If you were affected by COVID-19, just fill out this little declaration by signing it and dating it and giving it to your landlord, and your rent is deferred until January 31st, 2021. Now, the legislators and our wonderful governor were insidious in what they said, because normally, if you had until January 31st of 2021, that's a lifetime away. But at least if the tenant did sign the declaration, he got it back to you. So now you know that your rent is deferred. In that situation, at least by January 31st, if you don't get your rent, you'd be able to now proceed forward with an eviction, right? Right? And the answer is no, because the legislator and our governor were insidious, because they have now renamed the word rent. I don't know what that means, but that's what they've done. They've renamed that word civil debt. It's a civil debt. It is no longer considered rent. What's the significance of that, you might ask? Well, very simple. When the tenant doesn't pay you that rent that was deferred until January 31st, well, after January 31st, that's now a civil debt. If it's a civil debt, you can't serve a 3-day notice or a 15-day notice to pay rent or quit and initiate an eviction. You can only initiate an eviction if it's rent. And our legislature declared that it's a civil debt. So how do you get your money? Interesting question, because remember, they're talking about deferred rent. They're not talking about rent forgiveness, but in effect, that's really what it is. Under this AB 3088, that rent that they didn't pay from March through August, where they gave you that declaration declaring that it was due to the pandemic, that becomes a civil debt come February 1st, and you are allowed to file a civil lawsuit, not on February 1st, on March 1st. I don't know where they get these dates, and I'm just telling it to you, so I know you're confused, but that's what it is. So on March 1st, you could file a civil lawsuit. Could you go to small claims court? Yes. In fact, they've expanded the limitation on what you can ask for. Normally it's 10,000. Now it's unlimited if it's considered civil debt for that time period. So you as a landlord didn't get your rent sometime, maybe every month, but sometime between March and August, you served the 15-day notice with the information sheet and the declaration. The tenant gave you back the declaration within the 15 days. Now you know you can't even think about that rent until January 31st. After January 31st, the rent should have been paid to you. If it isn't, it's now a civil debt, and now you can go on March 1st into small claims court and sue for that money. But again, if you do win that case, it's just a judgment. It's not like you can get the tenant evicted. You then have to collect on it if the guy's got no money. Or what happens if the guy moved? How are you going to serve him with the small claims court lawsuit? If the guy's in your property, you know where he is, but what if he moved? In effect, ladies and gentlemen, what we're seeing is that that rent for the period of March through from March through August 31st is basically lost. We have a state-sanctioned taking, and believe me, there will be more federal lawsuits on this one, taking money from landlord that'll never be recouped. Now, if in fact the tenant doesn't return the declaration within the 15 days, that means you can file a lawsuit. By the way, when you count 15 days, it's not calendar days. You have to exclude Saturdays, Sundays, and legal holidays. So that's a 15-day notice. It's probably a 25-day notice. That's how much time they've got to either pay you the rent or return the declaration. The declaration's under the penalty of perjury, but I don't think there's any governmental office that's going to be prosecuting a tenant who lies on that declaration. But let's pretend the tenant does nothing. He gets the 15-day notice with the information sheet and the declaration, and he doesn't return it within that 15-day period. Now we have the right to call that wonderful law firm, Dennis Black and Associates. The phone number is over my right shoulder, and we can start an eviction. But guess what? They wrote a little extra into that code section. And it says that once we file that lawsuit, that the tenant, once he's served, can then file the declaration with the court. Well, that's way past the 15-day period. And if he files the declaration with the court has to set up a hearing within 5 to 10 days. And then at that hearing, the judge is going to determine whether it was excusable neglect of whether the tenant missed his 15-day period. And if the judge finds that it's excusable neglect, then the case is dismissed. And all the money you spent on the attorney's fees and the filing fees to get that case started is thrown out. If the judge finds that it was excusable neglect, you know, the tenant's going to come and say, I don't know, I got all these papers, I didn't know what to do with them. This is a horror situation, ladies and gentlemen, as to this code section. But I'm merely here to report as to what it states. And what it states literally is a taking, a constitutional taking from income property owners. So that's what we're talking about with regard to the protected time period. Let's move on to the transition time period. That's the rent that's owed as of September 1 through January 31st. Now, I might add that all these issues are over as of February 1st. So as of February 1st, 2021, you can serve a 3-day notice. If that tenant doesn't pay February, don't go back to anything before February, you can go forward with that 3-day notice. And if the tenant doesn't pay, then you need to proceed forward with an unlawful detainer come February 1st. But from the transition time period from September 1st through January 31st, if your tenant doesn't pay you rent for that period, you have to serve an additional 15-day notice. You can't combine the two for the two periods. So we've been serving 2 15-day notices to pay rent or quit, one for rent from March to August, and then another one from from September through January, okay? Now, with the one that the 15-day notice that I'm serving for the transition time period from September to January, that too is a 15-day notice. That too has a different information sheet, and that also has that declaration. So what does the information sheet say for the transition time period? That says to the tenant, hey, if you're affected by the COVID virus and you couldn't pay rent for that time period, then your rental obligation is excused as to 75%. As to 75%, your rent is excused, and you only, assuming you return the declaration, you only, within 15 days, you only have to pay 25% of your rent. So if your rent is $1,000 and it was owed for September, I would serve the transition 15-day notice information sheet. And the tenant within the 15 days, all he's got to do is give back that declaration, and all he has to pay is 25% of the rent. Now, let me tell you how silly this one is. When do you think he has to pay the 25% of the rent? Well, if you had any logic, you would say, well, within the 15 days, I've got to return the declaration. And then I've gotten the declaration that says 25% of the rent is owed. So I'm going to have to return the rent, 25%, only 25%, within the 15 days, correct? And the answer is no, it's not within the 15 days. The tenant still has through January 31st to pay the 25% of the rent. And if he doesn't, then on February 1st, you could go forward with an eviction. But remember, as to the 75% of the rent, that you can't ask for, and that too changes its name. It's not rent anymore. It's a civil debt, which means that you could only sue for 75% of the rent owed from September 1 through January 31st in a regular civil lawsuit or in small claims court come March 1. So if we do the math here, we're not even talking about local jurisdictions, which I'm going to get into in a second. You could have a tenant who literally didn't pay rent from March 1st through January 31st. It's 11 months worth of rent where almost all of it is going to be considered civil debt, and you're going to have to chase your money. And even if you get a judgment, good luck on trying to collect it, even though my firm does do collections and we're pretty successful, but still, good luck. So what the legislator and our wonderful governor has done is stolen 11 months of rent from you. I mean stolen 11 months of rent of anybody who merely signs a declaration. So to recap, you've got three 15-day notices, one from the protected time period, March 1 to August 31st. The transition time period would require another 15-day notice with a different set of information sheets to the tenant. And that would be for the period of September 1 to January 31st for that. The Act also does other things. It requires that any residential property up until January 31st requires good cause as enumerated by our statewide rent control statute. So even though, for example, you have a condo, you have a single family home, and you're trying to market it, and there's tenants there who are on a month-to-month tenancy, any time prior to this dastardly AB 3088 promulgated on August 31st of this year, you could have served that tenant with a 30 or a 60-day notice to get out so that you could, I don't know, fix the place up and try to market it for sale to your clients. But right now, that tenant is now protected, that you're not allowed to just serve a notice to terminate. You're going to have to wait at least until February 1, when this terminates, to be able to easily get rid of that tenant. We actually can serve a 60-day notice now, but we can't enforce any eviction until at least February 1. So good cause applies. Now, there is an exception, and that is if the property has been sold, it's in escrow, and the buyer intends to move in, that would be an exception. Or if you're under some building and safety order that you have to make certain repairs or demolish the property, then the tenant would not have any protection. But again, under this statute, AB 3088, you have to have basically good cause to evict. You could do it also on the basis that you want a family member to move in. Now, these are properties that were not under any rent control. It was a single family home, or let's pretend it was brand new constructed, built, let's say 5 years ago. So it's not under any rent control statute, and it's not under statewide protection. You do, under this statute, have to afford the tenant protection in terms of just being evicted for no fault up until January 31st. Okay, so I've gone through what it states in AB 38. I know it's really confusing. I did try to go a little bit slowly and repeat myself a bunch of times. And that's why I'm holding off telling you what I'm going to tell you now, because hopefully you weren't thoroughly confused by what your requirements are now for a tenant not paying rent. But now I got to tell you one more thing. And if you weren't confused before, you're really going to be confused now. Now there's no hope. So here we go. One additional part in this bastard statute is that if your property is subject to a local eviction moratorium that is more onerous than this statute, then you got to comply with your local eviction moratorium. What the hell does that mean, ladies and gentlemen? I don't know what that means, but I can guess. And this is my guess. So you have a tenant that owes rent from March to August. That would be the protected period, or for the transition period. He didn't pay you for the September or forward in time. So I just told you all this wonderful stuff about sending a 15-day notice and serving the information in the declaration. But wait a second. My property's located in the city of Los Angeles. Well, the city of Los Angeles has an eviction moratorium. So now I got to comply with that one. Well, what does that one say? Well, that one says that if, in fact, the tenant has merely just told you, he just mouthed the 3 following words in any particular order: COVID-19, coronavirus, or pandemic. If he's mouthed those words to you, according to the city of Los Angeles, that tenant's rent is deferred for 1 year. 1 year. And you can't even serve a notice to pay rent or quit. So you're basically forced not only knowing what the state law says, you also have to reanalyze it to your local jurisdiction. If you're in a local jurisdiction that doesn't have an eviction moratorium, then you're free to comply with the state. But if it does have a local jurisdiction that deals with eviction moratorium, then you've got to comply with that. So for example, unincorporated areas of LA County has their own eviction moratorium, but LA County also said, hey, if your local municipality doesn't have an eviction moratorium, let's take Alhambra, let's take West Covina, let's take Montrose. If it doesn't have its own, then you come under our auspices of the LA County. So LA County, which thank God is going to be over as of the end of this month, states that, again, if you said those magic words, you can't even serve a 3-day notice. So for LA County, you can't do anything until October 1st. On October 1st, when their statute finally evaporates, and we also believe that the city of Los Angeles statute, though we're not sure, will evaporate as of September 30th. Now we can start talking about a 15-day notice in complying with the state law. So I am advising everybody that in order not to run afoul of the law, that they really need to have an attorney who knows what they're doing, evaluate your particular situation. We're recommending that we serve these notices. It's really just too complicated not to. So be it commercial or residential, I would recommend highly that you check with our office and we can assist in preparing the notices. We are going forward with a ton of eviction cases right now. I am so happy to tell you, and I'm sure my clients are happy to tell you, because we've kind of meandered through this path to allow us to bring forth eviction cases now. But there's certainly a percentage of cases that run smack dab into AB 3088 and doesn't allow us to proceed forward with these eviction cases. So again, call us up. If you can't see my number behind me, it is 1-800-77-EVICT, 1-800-77-EVICT. Before I open it up to questions, I want to make sure that everybody is familiar with this. This is No on 21. This will gut our industry. Well, I'm always political, so might as well really get political, right? This will gut our industry. This will prevent landlords where there is a vacancy from raising the rent on a vacant unit more than 15%. So if you were tremendously under rent control and you were waiting for that particular tenant to die or to vacate the unit, and finally they did, so now you could finally get out of the auspices of severe rent control, and you could raise that rent to merely market value. If this Proposition 21 passes, you will be limited to a 15% rent increase. This is socialism at its highest form, ladies and gentlemen. Anybody and everybody who you know, get them to the polls or doing your mail-in ballots, whatever you can do. We must defeat Proposition 21. This will gut our industry, ladies and gentlemen. And now that I said that, and now that I have everybody confused, let's open it up for questions. I'm going to take questions for about, I don't know, 20, 30 minutes at most, because I do got a little practice to run here. So if anybody's got any questions, somebody's going to feed me some questions, and I'll see what I can do about answering them. So go ahead.
Thank you, Dennis. We have a lot of questions for you. So, but we'll go through it one at a time. So question we have from Victoria Stapleton. She has two questions. So question number one, the seller in the city of Alhambra have a triplex, 2 units occupied. Question number one, if the new owner wants to vacate the existing tenant, can they do so during COVID? Question number two.
They actually can. If the property is in escrow, then the current owner can serve a notice on the basis that the buyer intends to move in. Since this is a triplex, you would have to pay relocation because it's going to come under the statewide rent control. The relocation is only 1 month's rent, but that is certainly doable.
Okay. Question number two she has is, if the tenants from the same triplex that she mentioned, if 2 tenant families, no children in a triplex continually argue, and the 2 males threaten each other and challenge to a fight, after repeated warning, what is the next step to evict both of them during COVID?
Are these 2 separate units? Is that the way the question was written? Or yes?
Yes, this is a triplex.
Okay, so there's 2 tenants in different units that are fighting, correct?
Correct.
Okay, well, if the owner can determine who is the aggressor and who is the victim, then a lawsuit should be brought, which can be brought at this time. There's no impairment because we're not talking about rent, based on nuisance. But the problem is going to be a he said, she said situation. So I would certainly start by writing warning letters to both tenants. I would, in the warning letter, explain to the tenants that they're creating a nuisance and they are going to be subject to an eviction, that they should have no contact with the other tenant, that all issues and problems should be brought directly to management first, and then let us deal with it. But if somebody gets aggressive with the other person, they will be the subject of an eviction, and we could go forward with that.
Okay, great. There's another question from L. A tenant made partial rent payment for September, which is this month. The tenant said that he will pay in full later. Can landlord charge late fee?
No, under the governor's order, there are no late fees. If the tenant is claiming, at that point in time for this one, unless the tenant has stated that the reason he's not paying is because of the pandemic, then we have the right to serve that tenant with that 15-day notice, giving him 15 days to either pay the balance owed for September or to return the declaration, where, of course, he'll still be liable for 25% of the rent. Since he paid a partial portion, most likely that 25% of the rent has already been paid. So the rest of that rent, assuming he signs that declaration declaring that it's because of the pandemic, that again, that rent would then be transmuted, as the statute states, to civil debt, and he really wouldn't be able to get that debt until filing a small claims court action in March.
So next question from Jim Viga. Scenario, a deadbeat non-rent paying tenant owns from January 2020, but plot thickening, someone in the household contracted COVID-19. Can we evict?
And the answer to that is, let's do a drum roll here. The answer to that is absolutely. That is a wonderful case for eviction, and that landlord should be happy that the rent is owed for that long, because as I stated, rent that is owed prior to March 1st has no protection under the law. So in that situation, I would immediately be serving a 3-day notice, not a 15, a 3-day notice for the January and the February's rent, and I would start that lawsuit immediately. So that's a phone call to me as soon as this Zoom is over.
Next question from Cecilia Ruda. Can the landlord file a class action against the state for financial harm?
I believe so, and I think this should be a federal action. I am exploring it. I haven't jumped into the bucket yet, but we are exploring doing that. I mean, we were very successful with our lawsuit against the Judicial Council, who basically put up the white flag and gave up before my case actually was pending before the California Supreme Court. But then the Judicial Council just gave up and revoked their illegal emergency rules. So I'm still waiting for the court to make a decision to prove at least that it was illegal. And I think what the state is doing is, so check my website out. We're going to see if we're going to be filing something on that. We already have an exploratory committee going forward, and this would be filed in the federal court.
Okay, great. Next question from Mindy Ye. A commercial office property is in city of Covina. New owner can my client allow to implement a new lease with current tenant and increase rent? Tenant's current lease with previous owner is month to month.
Nothing prevents landlords in commercial situation from raising rents to market level. So that certainly is doable. There's nothing that talks about it. Remember, the new statute really doesn't involve commercial cases. So we would only have to worry about LA County and their protection for commercial cases, which, by the way, states that tenants are protected, commercial tenants are protected. And I believe for the county, they have 6 months to repay that rent once the pandemic is over. They're claiming that it's over as of September 30th. So, but you're certainly free to enter into a new contract with this commercial tenant for the market rent.
Next question, Nanette Ohm. When can the 15 days notice be served for a protection period and for a transition period?
Well, as soon as rent is owed. So right now, today, this morning, I prepared for 2 different clients 2 15-day notices because rent was owed between the protected time period and also owed between the transition time period. So we're serving those notices. If I don't get declarations back, we're going forward with an eviction on that case. If we do get the declarations back, then I'll be advising my client in terms of when and where we'll ever see that money again.
Okay. Next question, Jerry Tian. If commercial tenant did not pay rent on March, but he paid April rent and after, what can I do?
He paid rent for what month?
March. No, he did
Okay,
not
so-
pay rent for March, but after
Okay, so-
March, he paid.
So we have a tenant now who hasn't paid rent from April through August, and we also have a tenant that hasn't paid rent for September. So depending on a local jurisdiction prohibition, we could serve 2 15-day notices and proceed forward with evictions unless we get the declaration back. I did want to say one more thing, which I forgot to say during my topic, and that is there's another requirement that landlords must comply with, and that is if anyone is owed rent between March 1st and September 30th, anywhere, any residential tenant in the state of California, there's a form. I don't know if you can see this, but this form needs to be served on any tenant who owes rent for any reason from March 1st through September 30th. If rent is owed, this form needs to be served. I'll have this on my website shortly, but or you can get it on some of the apartment associations' website, but this form needs to be served. Don't forget that. That's in addition to anything else I've talked about today. Let's move on. Next question.
Okay, next question. I make sure it's from Jim Viga again. I make sure I raise my rent every chance I got. I make sure the rent were at or above the area level. Did my greed help promulgate all this rent activism?
I'm not sure what you mean, but I think it's a smart idea, obviously, to always keep your rents at market value. We have no idea what legislation looms and what politicians will do to us. Maybe next year they'll just pass a law that says, you know, we can only collect rent every other month. I mean, who knows what they're going to do? I certainly wouldn't put it past them. But yes, I think that was very intelligent to keep your rents at market value when they were trying to pass Proposition 10. And of course, I got into a lot of trouble from all the media when I advised landlords to either raise rent or evict tenants at that time because you could. And I got into a lot of trouble from the LA Times and a lot of other people for giving that advice. But I can tell you that I literally received over 1,000 letters, I kid you not, from landlords who took my suggestion, got rents to market value so they weren't under the auspices of this new statewide rent control, which literally has damaged so many landlords up and down the coast of California.
Okay. Next question from Rita Choi. Property at San Gabriel City, but belongs to LA County. Can we start eviction process on October 1st?
Yes, you can start it by serving a 15-day notice. So I would presume the tenants are owing rent. And it's imperative that we serve these notices when rent is owed because we want tenants to declare that it's pandemic related. We want to put them on notice that they're going to have to sign something under the penalty of perjury, even though we know they're going to work every day. We know that their job is not affected. And by the way, you know, across the state, across the country, unemployment's at 8.5%. 8.5%. Everybody else is working. There's no reason for people not to be paying rent if you're working. And if you're not working and you're one of those 8.5%, God knows you got unemployment. God knows you got the handouts from the federal government. and you were probably making more money. So this is truly an abuse by so many tenants out there that it's beyond belief. And of course, you know, it's these do-good politicians that are trying to curry favor with tenants to get votes, which is why this is moving forward. We have a guy who rented I just was talking to the client this morning, rented an apartment, never moved in, just used it to do Airbnb. That guy's claiming COVID. I mean, this is so against what the law was trying to protect, and trying to protect it on the backs of landlords. Like we should be the saviors for the whole country. Landlords should, because they don't make realtors chip in their commission checks, right? The tenants who can't pay rent. So why are landlords the only segment of society that are forced to support another segment of society with our services? You know, let everybody chip in, let markets chip in, let realtors chip in, let doctors chip in to tenants to pay their rent. Why is it only landlords? But I guess we shouldn't get me started here. So I'll move on to the next question.
Okay, I know we still have a lot of questions, but let's just do one more. From Cecilia Ruda, what about guest houses and legal ADU rentals? Does this AB 3088 apply?
Yes, it applies to any rental. It doesn't matter that it's a single family home, not under rent control. It was a brand new one. It's not subject to rent control, but it's subject to this eviction moratorium where rent is going to be basically waived, or it's going to be transmuted to civil debt.
Okay, well, thank you for all the answering the questions, and I know we still have a lot more. If anyone wants to ask questions, feel free to contact Dennis Block, and his contact information is on the screen.
That is true. I have my actual number there, but I also have an 800 number behind me, 1-800-77-EVICT if you can. You guys are always great. You guys are a great audience, and I certainly appreciate the opportunity to address you. Again, if you got any questions, we don't charge for a phone call, and always appreciate the opportunity. And hey, you know what? There'll probably be a new law tomorrow, so give me a call back.
Thank you, Dennis Block. On behalf of West San Gabriel Valley Realtors, we'd like to thank you, our guest speakers, and we are honored to have Mr. Dennis Block to join our meeting today and giving us the valuable and important information on the Tenant Relief Bill, AB 3088. Again, you can contact him for any other questions. Now we'd like to move to our attendance drawing. Please type your member name and email in the chat box when your name is called. Our first winner, it's Yen Ken Sai. So if your login name is different, please make sure to type in your DRE name and your email address.
That's Vicky Tai. I don't think she's here today.
Okay. Vicky, are you here? Let's see. Is she here?
No, I don't think so.
Nope, she's not here. Okay, let's move on to the next one. Do we have the music for the spinning? The next one's Willa Laura. Is she here? Willa?
I don't see her, him or her.
Willa, she?
No.
Nope, okay. Next one.
Albert Spin has no noise now.
Yeah, what happened to the music?
I think Park Hee is here. Park Lee, he, I think is here. I saw his name. Let's see.
Pak Lee, can you please type in your name if you're here?
Hold on, he's here. Let me see where he is. Let's unmute him.
Trying to unmute him.
Did you try to unmute him?
Yes.
He's not even unmuting himself.
He
I
probably
think
stepped away.
he just put it, he put here. Please type in your email address so we know we can send you some information. He just typed here.
Congratulations. So far, you're the first winner.
I don't see his, did he type it to you directly?
Oh, he typed it to me. He typed it to me.
Oh, yes.
Okay, let's move on then.
Yes. The second winner. Oh, there you go. We have the music now. Jessica Lee, our second winner. Jessica Lee, are you here? Is she here?
Hold on, I'm still trying to give Berlin emails.
Thanks.
Okay, let's find out if Jessica Lee is here. No, Jessica Han is here, not Lee. Let's move on.
Okay, let's move to the next winner. Our next winner is Xiao Ding Zhang.
I don't think this person is here. Albert, try to pick people that's here.
Xiao Ding Zhang, you here? No. Okay, let's move to the next one.
I wish I can control it. Alex, I thought I saw him.
Alex Tsai.
No, Alex Tsai is not, but Alex Lee is here.
Maybe we can cross the last name.
Albert, you're picking people that's not here.
I don't know why. We have too many people today. Register.
Second winner of the day, Richard Zalauta.
Zalita.
Zalita, I'm so sorry.
Oh, he's not here.
No one's here.
Oh no.
Albert, you don't have the magic touch. Hurry up, Albert.
What to do?
Adam Lam said he's here, but you're not picked, Adam. Oh,
Linda
Lam is, I think she's here. I saw her name.
Linda,
yeah, she is here.
Cheers.
Linda, please reply. Let's find her and unmute her.
Can somebody unmute her?
I'm
Trying to unmute her. She needs to unmute herself.
Linda, please unmute yourself or type in you're here. Linda, we try to unmute you.
But you can type in your name on the chat box.
Another one that opened the computer and left us out in the cold.
Adam, type in I'm here. Sorry, but we haven't called your name yet.
Adam, maybe you're next. Okay,
Yes.
This person, we try to unmute. We try to ask the person to type in here is not replying, so we're moving on.
Next one will be here. Gary Penn, he's here.
Gary Payne.
Oh, he's not.
Gary, are you here? I don't
Not
have
here.
Gary Penn. Who
Not
says
here.
here? Not here.
Not here.
Albert,
I don't know.
what's going on with you, Albert? You don't have that magic touch anymore.
At least we get the first person.
Pack is the first one that replied. Oh my God. I don't think this person is here. Arsha. Yes. He or she is here.
Oh, yeah, they're here.
Yeah, yes. Hello, could you apply, please?
They're here.
Make sure you put in your email address so we can send you the gift card.
Please reply. Please.
Hello.
So
yeah.
we can move on.
He's unmuted too.
He's not replying us. Oh, hold
Oh,
on.
there he is. There he is. He replied.
Oh, he
Oh,
replied.
yay!
Okay, thank you. Congratulations for all 3 winners.
No, I think it was only 2.
It was only 2.
It was only 2.
Linda and
Linda then never replied.
Oh,
Did
so
she
you
reply?
have the 2 winners.
We have
names.
another one. Okay,
Okay.
let's go. One
All right.
more. Hurry up.
See my magic touch.
Sunny?
Sunny Zhao. Are you here?
Not that I know it. Belen, do you see the person here?
I saw Linda. Linda says she's declining the price. Thank you. She typed in the chat box.
No, Sunny is not here.
Okay, yeah, Linda just text.
One more.
Albert, please hurry up.
This one probably there.
Jessica.
Jessica Han. Congratulations. Are you here?
Here?
Yes,
yes, she's here.
yes, Can you
Okay,
type in your
great.
email address, please?
Yes, I'm here.
All
Can you
right.
type in your email address, please?
Sure.
Thank you.
All right.
Congratulations.
Okay.
Okay, now let's move on to our education classes. Our first one is the kickboxing this weekend, Saturday at 10 o'clock. It's coming for the members appreciation. So please sign up and join us this Saturday. Next class is the license renewer, DRE, 45 hours continuing education. The cost is $45. We have 2 classes. One is September 11th and the 18th at 9:30 to 12:30. Next one is the virtual zip form plus training. It is September 14th, 2020. Time starting at 10 o'clock to 11:30, and it's Monday. The third one is Save at Home and Learn, Understanding Credit and Optimizing Your Credit History. It is September 15 at 11 o'clock to 12. The next one, Global Real Estate Market Trend, Emerging Real Estate Market in Peru, South America. It is next week, September 23rd at 11 o'clock. Please sign up for these classes and join us. Okay, thank you everyone for joining our meeting today. We hope to see you again next week when we welcome our speaker, Christian Hoisred, political representative from National Association of Realtors, NAR. Please support our affiliates with your transaction, and please don't forget to register our next meeting, MLS meeting at September 18th, Thursday. This meeting is now adjourned. Please be safe and be well with all the fire going on. And one more thing, we will have the MLS meeting after this. So please join the MLS meeting for the MLS members only. Now we are closing. And again, goodbye, everyone.